Good evening, everyone who's joining us, and welcome to this monthly Facebook Live session that we run from the EU delegation to the UK's Facebook channel. My name is Chris Ben. I'm an immigration lawyer with a solicitors firm called Seraphus, and the idea of these monthly sessions is to talk about the EU citizens' rights in the UK post-Brexit, looking at things like the EU settlement scheme, the EU withdrawal agreement with the UK, and citizens' rights in general after Brexit. So for anyone who's joined the sessions before, welcome back. And the idea is that you'll know the format. It's a pretty straightforward approach that we take. So anyone joining for the first time this evening, how it works is we have about an hour until 6:30, and we will run through some sort of presentation, some slides covering information on a particular area that we'd like to address and give people information about. And then in the sort of second half of the session, we will look to answer any questions that people have, either about the topic that we're covering or about anything else to do with citizens' rights. Feel free to ask the questions that matter to you. We'll do our best to answer them. So that's the format. It is, as I say, pretty straightforward, and so we'll look to try to cover everything we want to talk about and all the questions within the hour that we've put aside. So as you can see from this the presentation slide, what we're going to discuss this evening is family members under the EU settlement scheme, and the reason why we want to touch on this topic is that we received a request to cover some aspects of family member applications, because as we'll see during the presentation part of this evening, there are some quite complicated rules that apply to family member applications. So we've been asked to cover this, and just to be aware that we will always welcome feedback on the presentations, on anything to do with citizens' rights, because we want to focus on the issues that people want to understand better and have perhaps struggled with. So if you have any suggestions for our October session, then do feel free to post those to us either in the chat or using our social media channels, which are available obviously all the time, and we do respond to questions posted on our social media as well. So just to be clear, if you don't want to add a question in this evening, but you do have a question, then feel free to use our social media channels to ask us that, and we'll always try to come back with information if we can answer the question. Some of these issues are quite complicated. So that's why we've picked up on this topic this evening. It was a specific request, and it is a useful topic to discuss, because family member applications are very important, but they do have added the criteria that makes them more complicated than what you would sort of term a standard application to the settlement scheme. So an important topic to cover. So we'll break it down into a few different areas of family member applications, but obviously one thing that is really important is to make sure that if you are sponsoring a family member application, that you are sponsoring what we would call an eligible family member, because if you try to sponsor an ineligible family member, obviously they are not going to be successful, and their application will be refused. So we don't want that situation to arise. We don't want people to be disappointed by not sponsoring the right family members. So this list here is the eligible family relationships that are covered by the withdrawal agreement, and therefore they're covered by the EU settlement scheme, because the EU settlement scheme is required to give effect to the obligations of the withdrawal agreement in terms of which family members can join you in the UK, or which family members living here already are able to secure status under the scheme. And we'll come back to where your family members might be at the moment in the later slides. So just to set out the family relationships, we have spouses and civil partners where the legal relationship existed by 31st of December 2020. That date will remain important because that was the date that the kind of legal relationship with the EU and the UK ended, as the UK being subject to EU law, and it's the date that withdrawal agreement law took over. So you have to have your relationship in existence by this date. And obviously, it's a legal relationship. It's pretty straightforward. If you were married legally by that date, or if you entered into a civil partnership by the 31st of December 2020, that is a legal relationship, and therefore you can sponsor that family member. You do have the possibility, if you weren't married or in a civil partnership by that date, but you were in a serious relationship, there is the possibility of sponsoring what is known under the settlement scheme as a durable partner. It just means a sort of unmarried partner where the couple is in a serious relationship. But again, the serious relationship has to have existed at the 31st of December 2020 and continues as a relationship in order to qualify. I'm going to come back to durable partner applications because they are a little bit more complicated than spouse or civil partner applications. So we're going to focus a little bit on what the durable partner applications entail. You also have children and grandchildren covered by the settlement scheme. And for the purposes of the settlement scheme, a child under 21 years old is essentially considered dependent on you. So you can sponsor them as a child under 21. There's no additional criteria, and you can sponsor adult children. So that means children 21 years and over, but they do have to be dependent on you as that relationship. So it requires an extra element if you're sponsoring an adult child that they have to be dependent on you. So that's the distinction with children, but any child under 21 is eligible automatically. And that applies also to grandchildren. And then the category, you have parents and grandparents who are dependent on you. So again, there's this element of dependency, and I'm going to come back to that so that we're clear on what dependency looks for and what it means in the application. But your parents, your grandparents are covered. There is an additional category of family members called other dependent relatives. So it means like more extended family relationships such as siblings or cousins, uncles, aunts, not limited to those, but that's the types of extended relationships we're talking about. So they are covered by the settlement scheme, but only if they receive or they applied for a document under the EEA regulations. This was a set of regulations that existed up until the 31st of December 2020. So these family members, they had to apply for a document to be issued under the regulations, and then they could apply to the settlement scheme. So what that means is it's essentially it's a fixed group of family members who have the regulations document issued, and if they don't already have EU settlement scheme status, they could apply. They would be a late applicant, but they could apply for status under the settlement scheme. But then it basically means there are no new applications for these more extended family relationships. They're not something that you can apply for under the settlement scheme unless they have this document issued under the regulations. So they'll know if they have that because they'll have already made an application to the Home Office. So that's broadly that is your list of eligible family members. But I just want to touch on a couple of additional things just to be aware of. When we talk about dependent parents, grandparents, so normally you have obviously we're talking about relationship with an EU sponsor, an EU citizen sponsor who themselves has pre-settled or settled status. The sponsor has to be an EU, an EEA or a Swiss national, and that person has to have been resident in the UK by the end of 2020. And in the majority of cases, they also have to hold pre-settled or settled status. There are some exceptions to that. For example, Irish citizens might not need to have pre-settled or settled status, but most sponsors do need their own grant of status. So normally you're talking about the relationship between that EU citizen and their family member being sponsored. However, it is possible, if you are an EU citizen and you were married to a non-European national, and your marriage took place by 31 December 2020, you would be able to sponsor that your spouse's parents or grandparents, if they are dependent on you, and if your spouse had children that are not your biological children, you could also sponsor your children in those your spouse's children in that situation. And so it's possible that you are talking about sponsoring a family member as an EU citizen who is not biologically related to you. So that is something that is possible, but it applies where you have a spouse or a civil partner and you're looking to sponsor their family members. If you are talking about children being sponsored and the children or child is born after the 31st of December 2020, you must be biologically related to them, so that you as the EU sponsor must be biologically related to them. You cannot sponsor stepchildren if they are born after the 31st of December 2020. You could sponsor non-biological children if you adopted them. That's the only exception there. So it's just an important thing to be aware of with children born after the end of 2020, is there is a slightly different approach. When your eligible family member is sponsored under the settlement scheme, adult family members are granted pre-settled status, and then they are required they're not required. They can apply for settled status after 5 years of living in the UK as your family member. So that's the approach for adult family members. But children who are under 21 years old can be granted settled status immediately if their sponsoring parent has settled status. So there's a slightly different approach for children under 21, which gets them settled status, and they don't have to have lived in the UK for 5 years to access settled status. So that's an advantage for younger children, that they can get settled immediately. Okay, so one of the key things to understand is how a family member applies, because there is essentially two avenues in terms of how to apply, and changes that were made by the Home Office to the family member rules last year have actually made these two application processes they're more important to understand them now than perhaps they were previously. So we'll talk about why that is shortly. But essentially, some family members can apply directly for pre-settled or settled status, so they essentially apply directly to the EU settlement scheme for their status. But some family members are required to first apply for what's called an EUSS, an EU settlement scheme family permit, and then after they get granted that family permit, they can apply for pre-settled or settled status. So there's two approaches. It doesn't change the family members who are covered by the scheme. So the eligible family members that I just ran through, that does not change if you use one application route versus the different application route. There's nothing that's different about which family members can qualify. It's just the process that they go through to get their status. So essentially, when you're looking at making a direct application for pre-settled or settled status as a family member, this can be done inside or outside the UK, but only EU, EEA, and Swiss family members can apply directly to for pre-settled or settled status outside the UK, because only these family members would be able to use the Home Office ID app, and that's what you need to use in order to apply directly for pre-settled or settled status. So that's why it's limited to just those nationalities. But the one thing to be aware of is when you are applying directly for pre-settled or settled status, there is a deadline, or there may be a deadline for your application to be made, And if you've gone beyond that deadline, then you would only be able to have an application considered if you can show that you have reasonable grounds, justification, if you like, for missing the deadline. And I will come back to that point in a sec, because it is quite a complex question about what the deadline is for people to apply. If you cannot make an application directly for pre-settled or settled status, then your approach is to apply for an EUSS family permit. And that is an application that is made outside the UK. A family permit is essentially a type of visa, because what it does is it allows you as a family member who's being sponsored to travel to the UK. And once you've arrived in the UK, it allows you to apply for pre-settled or settled status. And so essentially that's that's what the process is for people who can't apply directly for pre-settled or settled status. And there is no deadline as a family member to apply for a family permit, so you don't have this issue of having to justify a late application because there is no deadline for someone applying for a family permit. So those are the two options available in terms of applying. So obviously with a family permit application, you're essentially going to make two applications. You're going to make the first application for a family permit outside the UK. You then get that granted, you travel to the UK, you make a application for pre-settled or settled status once you arrive. So you're having to make two applications. Whereas if you can apply directly for pre-settled or settled status, even if you're outside the UK, you're only making one application. And so it's a bit more straightforward. But what I was talking about in terms of deadline is really important, and this is because the Home Office changed the approach to deadlines towards the end of last year, and it has made life a little bit more complicated to know if you can apply directly for pre-settled or settled status. So I've tried to set out the deadlines that apply to people, because they're all different for family members depending on your circumstance. But essentially, if you've applied for a family permit and you've been granted a family permit, you can travel to the UK, and your deadline to make an application is the expiry date of that family permit. Now, family permits are generally issued for 6 months. So if you travel to the UK, within the first month of your family permit, you have essentially 5 months after arriving to make an application, because it's the expiry date that is the deadline for your application. In some cases, family members might hold a different immigration status, and what that means is like a non-EU settlement scheme immigration status, something potentially like a student visa or a working visa. It's possible that the family member being sponsored might hold a visa already or immigration status already. And in those situations, the application to move into the settlement scheme under pre-settled or settled status is it needs to be made before the expiry of that immigration status. So that's the deadline in that scenario. There is a small group of family members who would be considered exempt from immigration control, but that when I say small, I mean we are talking about a very small number, because that relates to family members who might be associated with diplomats, people who work for embassies, sometimes people who work for international organizations, something like the European Bank, or there's a list of international organizations. So it's quite a small group of people, but they are considered to be what's called exempt from immigration control. And if that applies to you, then your deadline to apply for status under the scheme, under the settlement scheme, is 90 days from when your immigration exemption ends. So that's a very niche category, but it does apply to some people. And then there's these two quite confusing deadline approaches, which are important to understand. But essentially, if you are going to apply as a sponsored family member, and you're going to be able to apply directly for pre-settled or settled status, if you have never been to the UK before, then or at least never been to the UK since January 2021, I should say. It's not about never being here before, but it is about if you've never come into the UK since January 2021, then you don't have a deadline if you're applying for pre-settled or settled status and you are outside the UK. There is no deadline for you. If you have entered the UK at some point after January 2021, but if it's your first entry to the UK, let's say you arrived in the UK in August 2025 for the first time, you've never been here before since January 2021, then you would have 3 months from your arrival. So 3 months from August, September, October, and perhaps a bit of November, depending on when you arrived in August. So you have 3 months from your arrival, but only if you have never been to the UK at any point since January 2021. If you have been to the UK at some point after or from the 1st of January 2021, the Home Office calculates the deadline for your application based on 3 months from your first entry to the UK. So, for example, if you came to the UK for a visit in January 2022, and let's say you visited for 2 weeks and then you left the UK, and then now you want to make an application as a sponsored family member, the Home Office would still go back to that visit in January 2022, and they would calculate 3 months from that, from your entry. So that would make it January, February, March, April 2022. And even though you were only visiting in that period and you left, again, as visitors should do, and your application as a family member is now being made in September 2025, the Home Office would still say the deadline is way long gone because you should have applied for your pre-settled or settled status. That's between, from your first 3 months of entry from that day in January 2022. So it's important to understand that, because it seems a little bit strange, probably, because you would say, well, I was visiting then, I wasn't intending to apply as a family member, and now I'm looking to join my sponsor in the UK, and why shouldn't the deadline be now? And it's a good question, but it's the Home Office approach. Now, in that situation that I've just described, the Home Office, they have a guidance document for their decision makers, their caseworkers, and it talks about joining family member applications, and particularly where someone may have visited in the past and now they're looking to make an application. And it does, and it gives an example of a good reason for applying after your deadline. If you've been a visitor, it's sort of basically, you can say, well, I legitimately visited. In my example, I legitimately visited in January 2022, and I left within a couple of weeks, and that's well within the visiting permission rules. And now I'm looking to sponsor, or to be sponsored as a family member, because I'm looking to move to the UK on a permanent basis. And the case working example says that should be a reasonable ground for making what they call a late application. So even though quite a long time has passed since the deadline, which would have been 3 months from your entry in January 2022 to your application date in September 2025, it's quite a long period has lapsed, because you can say, well, I was visiting under the visiting rules then, and now I'm looking to apply to secure my family member status. In theory, that should be accepted by the Home Office based on the way their caseworker guidance is written. So it is a bit of a complicated situation, but that's how the deadlines work for applications for pre-settled and settled status. And so just to carry on and explain, if you can't meet the deadline, on the next slide, we have a bit more information. So if you do miss the deadline, you can apply if there is a reasonable, what they call reasonable grounds. So essentially a justification. And I just ran through how you would try to justify what's called a late application if you had been visiting the UK in, my example is January 2022. So you can explain your reasonable ground is that you were genuinely visiting then, and now you're looking to apply as a family member. And so if the Home Office accepts that you have a reasonable ground for missing the deadline, then they will process your application. They will say, yes, it is acceptable to have missed the deadline, and you can now have your application processed. And the Home Office always has to assess every case based on the individual assessment of the facts, the information put forward by the applicant. And so it's important, if you're making a late application, to explain the reason why you are applying after the deadline that applied to you. And it's important to give a lot of information, because if the Home Office doesn't have a lot of information, then they are quite likely to refuse the application, or reject the application is the right terminology. So they basically say, no, we reject your reason for applying late. We're not going to look at the rest of the application. We're not going to see if you're eligible for status. We're just going to reject it because we don't think you have a good reason for missing the deadline. And if your application is rejected, it's very challenging, because it's difficult. It's not something it's not a decision you are normally able to sort of bring a legal challenge against. So there is a possibility, but it is quite a strict test that applies to bringing a legal test against this type of rejection decision. You could potentially make another application and try to explain better why you missed the deadline, and sometimes the Home Office will allow the application to proceed like second time around, if you like. Sometimes people come to lawyers like myself and they say, oh, well, I tried to make a late application and it was rejected, but I think that that's wrong. And so sometimes with a lawyer's assistance, that you may be able to present the case in a more strong light, and therefore it may be accepted if you have another go at making the late application. But sometimes it's just not possible to have the late application processed by the Home Office. So essentially you're left then without an application being made, and that's obviously not what you want, because you're trying to get status as a sponsored family member. So if ultimately you're not able to have an application for pre-settled or settled status made because you've missed the deadline and the Home Office doesn't accept you have a good reason for missing the deadline, and I'm talking about inside or outside the UK, it doesn't matter where you are if this is happening, it means that you have to apply for a family permit, because, as I said earlier, there is no deadline to apply for a family permit. So what you basically do is you have to apply for a family permit outside the UK. So if you are in the UK and your application has been rejected because the Home Office says we're not going to process it, it's late and we don't accept your reasons. If you're in the UK, you would have to leave and make a family permit application. If you're already outside the UK, then you can make a family permit application outside the UK. And the point is, you don't have to explain. There's no deadline, so you're not late when you apply for a family permit. So you just have to prove that you have a qualifying family relationship and that you should be entitled to your family permit. And then if the Home Office grants that, then you can use that to come into the UK. And because, as I said, the deadline for a family permit is the expiry of the family permit, once you arrive in the UK, you will be able to make your application for pre-settled or settled status, and you should be able to secure it that way. Because if you've been granted a family permit, then essentially the Home Office has accepted you are an eligible family member to qualify under the settlement scheme. So that's how deadlines work. I'm sorry, it's a bit complicated. It didn't used to be quite as complicated as that, but that is what it is these days. And it's important to understand the approach to be taken. So to kind of round off the presentation on family member applications, I'm just going to talk about a couple of the more complex situations, because we want to make sure that there's a good explanation of what happens in these applications. And so, as I said earlier, there's this category, what's called durable relationships, and these are serious relationships between unmarried couples. And so the rule is that you have to be in a serious relationship by the 31st of December 2020. And when you make your application, you still have to be in the relationship to qualify. So what is a serious relationship? Well, that will mean different things to different people, of course. And it's not something that is defined in either law or in caseworker guidance. It doesn't have a definition. So it's up to everyone to make their case. But there are a few kind of baseline things to take into consideration. And the first is that the Home Office, they look for 2 years of people living together to consider the relationship to be serious. And what that means is you have to be serious by the end of December 2020. So the Home Office says we want to see 2 years of living together before the end of 2020. So like really they're thinking you were living together throughout the whole of 2019 and the whole of 2020, and then we will accept that you have a serious relationship. So that's quite onerous, but it's because there's no strict definition. There might be scenarios where you have a serious relationship, a durable relationship, but it wasn't something that you were living together for 2 years. It might be that there was a different scenario. A good example given is where a couple have children together. That is clearly evidence of a serious relationship. And so it may be that the couple was living apart from each other for some reason, for good reasons, but for some reason, but they had children together, and that would potentially be indicative of there still being a serious relationship by the end of 2020. So it's difficult to kind of to give too many examples, because it will always be an assessment of people's situation and what it looked like, why if you weren't living together by the end of 2020, or even for 2 years by the end of 2020, what was your situation? Why do you can still consider your relationship to be serious? As I say, people live apart for many good reasons. They don't have to be living together to be in a serious relationship. It might be for education reasons, for work reasons, lots of different things. And so these types of cases always come down to a good explanation of what's been going on, backed up by evidence wherever possible. But it is still possible to qualify as a durable partner. But obviously, we are now in 2025. So we're going back like sort of almost 7 years. If you think about 2 years of living together before the end of 2020, we're going back to the beginning of 2019. So we're going back quite a way in terms of what kind of evidence will need to be produced to satisfy the durable relationship criteria. And there's something just to add to this, because sometimes people approach me and say, well, we didn't get married by the end of 2020, but we got married in 2021, 2022, or even perhaps more recently. And where does that leave us? And so the answer is from the perspective of the settlement scheme, at least, you're not considered to be a spouse, and you can't be a civil partner because you weren't in that legal relationship by the end of 2020. And that's the criteria. It's a binary criteria. Either you were or were not in that legal relationship. But if you have gone on to get married and your relationship did begin before the end of 2020 and it was serious by the end of 2020, then the fact that you've now gone on to get married or entered into a civil partnership is evidence of your serious relationship. It's just not evidence that it was serious by the end of 2020, because if you met your partner in December 2020 and you then married them in January 2023, obviously you're now in a serious relationship and you're legally married, but at the end of 2020 you'd only been together for 1 month, and therefore the Home Office is going to say, well, it cannot be serious in the context of what we apply, the sort of assessment that we apply to durable relationships. So it's all contextual. But if you were kind of in the relationship, you met each other in 2018, but you weren't living together because you were, like one of you was working in obviously you need a sponsor in the UK, your EU citizen sponsor is in the UK, but you were living overseas because you were continuing some studies or something. But you were in a relationship throughout 2018, 2019, 2020, and then you married in 2021, then that marriage would be evidence of the progression of your relationship. So it does play a part in assessing whether it was durable by the end of 2020. But these applications, they're pretty complicated, and there's not like necessarily, they're hard to advise sometimes, because some of them are borderline, and then you don't know how the Home Office will, whether they'll be positive or negative about the application. But if you're not sure, then as always, we advise to speak to a qualified advisor to understand if you might fall under this durable relationship category, because it's beneficial to be under the settlement scheme for a sponsored visa, and I'll come to why that is as some in the final slides. Okay, so that's durable relationships. Dependency, I wanted just to explain, because there's a few categories where dependency matters. As we've said, it matters for parents, grandparents, and adult children and adult grandchildren. And what dependency means in the context of the EU settlement scheme is it's the same meaning as it has under EU law, because that's what this is all about. It's about the withdrawal agreement, which applies EU law. And EU law dependency is about essentially it's about your essential living needs. So quite often dependency is a financial dependency between parents are being financially supported by you're being supported by your EU sponsor in the UK. That's the key, right? That's why you're dependent. So financial dependency, you are an EU sponsor in the UK, your parents or parent lives overseas, and you are sending them money so that they can pay their bills. That's financial dependency. But it can be related to medical needs, and it can be sometimes to do with social needs. If your parent has become very socially isolated and therefore is becoming dependent on you, then that might be something that meets the definition of dependency. And you could have a combination, because financial dependency, if you're paying your parents' medical bills, then that's financial, but it's also medical dependency. So sometimes you're talking about a combination of things that add up to dependency. But the way that the starting kind of question that if people are talking to me about dependency, what I say to think about is, what would happen if you're not there? What if you remove yourself from the picture? What's going to happen to your parents, your adult child? What will they do? Will they be able to get by? Because that's really what it's about. It's about the essential living needs. So it's a way of thinking about it is, if you are saying I send money to my parent, but it's to kind of help them, just with some luxuries, to have a holiday, or to buy things that they don't really need, but actually they've also got their own pension income, which is what they use to pay their rent and to pay for their groceries and stuff. Then in that situation, you're not providing for their essential needs, you're providing for extra stuff. And so it has to be about their essential needs if you stopped doing what you are doing. So that's the first question you ask to understand about dependency. But it doesn't mean you have to pay for everything. If you're looking at financial dependency, you don't have to be responsible for paying for everything. But what you have to think is that your financial contribution, is necessary to make sure that they can pay their rent, or they can have food to eat, or they can pay their medical bills. And if you stop giving them that money, they won't be able to do one of those things, or several of those things. That's where dependency would exist. So that's the kind of assessment. Again, it's always an individual. It's very fact-sensitive dependency cases. And in terms of sponsoring a family member who doesn't live with you at the moment, dependency can exist or it can arise in the future. It's not something that has to have existed today, and it doesn't have to exist for a set period of time. Sometimes people ask me about Home Office decision letters where they refuse an application. They say, "Oh, well, we don't believe you've been dependent for 6 months," and they say, "Oh, what's this? Is this 6 months dependency a rule?" And the answer is no, it's not a rule. There is no 6-month rule. Dependency must exist at the point when you're looking to sponsor your family member. So it's easier to prove dependency that has existed for a period of time. And so something that, if the situation has existed for 6 months, it may well be easier to prove the case than if you just say, well, actually my parent they weren't dependent on me until last week. That's a bit more of a challenge. It may be that that's true, but it would be potentially more challenging to prove in an application. So but it's important to be aware that there is no set amount of time someone must be dependent before you can sponsor them, as long as they are dependent at the point you sponsor them. And also the reason why they are dependent is not something that it's not relevant, in the sense that the Home Office. So again, like, think about financial dependency. If your parent is financially dependent on you, but they are still able to go and get a job, but they just don't happen to work, it is not possible for the Home Office cannot say, well, you are dependent, but we think you could resolve this by going, your parent could resolve this by going and getting a job. They can't say that, because it doesn't matter why they're dependent on you. So it doesn't sort of matter if it's a choice, if you like. It's just the fact is, if they are factually dependent on you, that's the only thing that matters. I wouldn't go as far. So if I was doing an application with a dependent parent or dependent child, I would generally explain why they're dependent. If it's something that's arisen, and often these things they arise. They might not always have been the case. They might have been the case for many, many years, but they don't. It doesn't always. It might be something more recent. So it can be very helpful to explain why the dependency has arisen. It's just something. It's not something that the Home Office can say, well, we don't accept that it should have arisen, the dependency. We think that they can do something about it. That's not a possible approach to take, but it may well be something that's important to cover in the explanation of the application. What happened if your parent was working and they were supporting themselves, but for some reason, let's say they got ill and they couldn't support themselves anymore, and you've stepped in. That's clearly a good, that's important information to understand what's happened and why they are now dependent, because they were working and now they're not, and they can't work in this case. So it may be important to explain it, but the Home Office cannot insist that someone resolves their dependency if they think that they might be able to. That's not a possibility in the way that the Home Office responds to the application. Okay, I'm just we're getting to the end. Hopefully this is helpful information. I know it's a lot of information because it's complex, but just want to cover children born in the UK. And the reason we want to cover this is because it is not a straightforward, children born in the UK are not always British. They might be British, but they're not always British. So it's really important to understand, because children who are not born British need to apply to the settlement scheme, because if you're their parent and you have either pre-settled or settled, well, if you're their parent and you have pre-settled status, then they may need to apply to the scheme for their own status because they're not British nationals. If they're born British nationals, of course, they don't need to apply to the scheme because they have British nationality, and that's their permission to live in the UK. So it's important to understand what are the rules for British nationality being conferred automatically on children born in the UK. And what this is about is the situation of the parents, because British nationality law says that if you have one parent, it doesn't matter which parent, but one of your parents is deemed to be settled in the UK, and they are ordinarily resident in the UK, then you are born British if as long as you're born on UK soil. So what it means, ordinarily resident, is a strange term, but what it means is essentially you're not temporarily in the UK. So you could be, your parent, for example, let's take the example of you have a British parent, but if that parent actually doesn't live in the UK, say they live somewhere else, but they happen to have been in the UK visiting their own family, and at the time when they have a child born in the UK, even though the British parent is settled, like they don't have any restriction on their immigration situation because they're British, so they can live here for as long as they want. But actually, their factual situation is they don't live here; they live somewhere else, and they're only temporarily in the UK. That British parent is not considered ordinarily resident in the UK, and so that parent is not deemed as settled for the purposes of their child being born British. So it does matter whether your parent who you're relying on to be settled lives in the UK or not. But most of the time it doesn't come up as an issue. So most of the time, if your parent is got the right kind of immigration situation, then they will probably be deemed to be ordinarily resident. But essentially, so if you have one parent who is British or Irish, then you are going to have a child born British if they're born here. If one of your parents has settled status, then the child is born British. If one of the parents has indefinite leave to enter or remain, that's a permanent immigration status, not settled status under the immigration under the EU settlement scheme, a different type of permanent immigration status, then you would have a British child. And the really complex one for the settlement scheme purposes is where you have a parent who has pre-settled status, which is not the permanent status under the settlement scheme, it's the temporary status for 5 years, but they have acquired permanent residence under the withdrawal agreement. Because you could have someone who has pre-settled status, but they've also worked in the UK for 5 years, and that person would have acquired withdrawal agreement permanent residence, and so they are considered to be settled from the withdrawal agreement perspective, but their EU settlement scheme permission looks like it's temporary permission, but it isn't a temporary permission because they acquired the right of permanent residence. So even if you have a child born in the UK and you have pre-settled status, both your parents have pre-settled status, that child may still be British. That's the kind of thing, the important thing to understand. But it's challenging to know if your child is born British in that scenario. The first question you ask is, have I lived in the UK for 5 years? If you've lived in the UK for 5 years and you have pre-settled status and you have a child, there's a decent chance that you will be that child will be British on the basis that you've acquired permanent residence under the withdrawal agreement. But it's usually something that you'd need to speak to a lawyer about to understand. But if you do have a British child, then you don't apply for them to get settled or pre-settled settled status. You apply for a British passport because that's what they're entitled to. But if you figure out, if you understand that your child is not born British, so let's say you have two parents who have pre-settled status, but both parents have lived in the UK for 4 years at the point when their child is born, then you know that those parents are not have not got permanent residence under the withdrawal agreement. So the child has to apply to the settlement scheme, and children born in the UK have 3 months to apply after their birth. Otherwise, they have to make a late application. Now, it's important to understand for late application for children that the Home Office will almost always accept the late application. They shouldn't really make a fuss about the deadline if you are applying late for a child, because it's a child and they're not in control of their situation. So almost every application for children, even if it's late, will be accepted. But it's important to try to apply within 3 months, because there are other consequences if you don't apply. The child is deemed to be without status, and that's not a good thing. So that's the key with children. Who are born here. Children born outside the UK very rarely are British, unless if they have a British parent, then they're quite often British. Not every case, but quite often. But if you're European parents with status under the settlement scheme and you have a child born outside the UK, they're not going to be British. Even if you have settled status, they won't be born British. Okay. Just to be aware that if your family member, for whatever reason, isn't under the EU settlement scheme, so if there's not an eligible family relationship that I've covered, then you would need to look at the non-settlement scheme immigration rules, because there are family visas that are available. Let's say you met your spouse, you met them in 2022 and you got married in 2024, then they have no eligibility under the settlement scheme because your relationship didn't exist by the end of 2020. So you would be looking for a spouse visa under the domestic UK family visa rules. They're always a lot more restrictive than the settlement scheme. There's more hoops that you have to jump through. They're more expensive because you pay for them. You don't pay for applications under the settlement scheme. And also, the list of family members covered by the domestic family visas is more limited than the settlement scheme. So there's lots of things about applying under the domestic family visa system that are disadvantage compared to applying under the settlement scheme. But obviously, only family members who are covered by the settlement scheme, those eligible family members are covered, and if they're not eligible, they're not covered. So you need to look at the non-EU settlement scheme visa rules. So that's just something I wanted to conclude with. Hopefully that's been helpful for people who are looking at family relationships. I don't know if we've had any questions that have been posted. My colleague Caroline is always diligently working behind the scenes to pick up on questions, but if there are, then I will crack on with those in a sec. So we do have some questions. I've just received them, which is very helpful. Right, let me just I'll just work through them then, because there are quite a few. Okay, I'll read out the question, obviously, and I'll try and answer. So once a child is granted settled status, but the parent once without 5 years of residency, can the child apply on form MN1 to naturalize as British, or must they accrue 5 years of residency? Oh, I see. Right. Okay. So what this is a question about is when a child, because you can, if you're not automatically born British as a child, you can apply to become a British national if certain situations, if certain circumstances arise. So you have to pay to apply to become British. That's the first thing to just be aware of. But some people want to do it. So essentially, a child has a right. If you have a child born in the UK, but the parents are not considered settled at the date of the child's birth, they are not automatically British. But if one of those parents goes on to become settled, so let's say you've got a parent with pre-settled status and 4 years residence, they have a child born in the UK. After that parent at 5 years of residence applies for settled status and they get granted settled status, so the parent becomes settled after the date of the birth of the child, then the child has a right to become British if they choose. They don't have to, they can just stay on the settlement scheme status, but they can choose to apply to register. You don't naturalize as British. If you're a child, you register, but you have a right to register as a child if one of your parents becomes settled after your birth. So that's one way of going about it. But if you're talking about children who are not born in the UK, then it's bit more complicated when they're entitled to register, because you look at the situation of the family members. It's what's called a discretionary application. So the Home Office looks at lots of different factors. So if you're thinking about whether a child not born in the UK might want to become British, then you need to look at the rules and the guidance on discretionary applications, because you need to assess the situation of the parents and any other siblings and so on. So it's not straightforward. Sorry, I'm just looking at, there's a few follow-up questions. Child born in the UK. Yeah, so the question then is, so someone's saying, so this situation, they're saying, if a child is born to a parent with pre-settled status, and presumably that parent did not have withdrawal agreement permanent residence, and the child has now acquired, and the parent has acquired settled status, should the child apply for settled status or apply for registration as a British national? So that's what I was talking about, that the right to become British arises once the parent becomes settled. The child has a choice, essentially. You can apply for settled status because your parent has got settled status, so you're eligible, or you can pay the 1,500 something to have a registration application. Sorry, maybe more like 1,200 for children. So you could choose. However, you actually want to get the child settled status before they apply to register, because until they register, until they're granted registration as British national, they don't have any status at all if they're born in the UK. So you want to get them settled status first, free application, just show them the parent has settled status, and then you can think about whether to apply to register the child, if that's what you want to do, if you're willing to pay the money. Okay, someone has asked if they can sponsor their mother-in-law, which I hope I've answered, in the sense that you need to, first of all, if you're an EU sponsor, you need to do you have a spouse or a civil partner? And if you do, and you're looking to sponsor if you have a spouse or civil partner and they're covered by the settlement scheme, after that, you then look at whether the parents of your parents-in-law, the parents of your spouse or civil partner, are they dependent on you? And I've covered what I mean by dependency. So that's how you know about whether you can sponsor your parents-in-law. It is possible if they are dependent on you and you have a qualifying spouse civil partner relationship. Okay, we have a question about the continuous residence rules. And this is the change in the residence rules. So I think this is not to do with family members. And as I said at the beginning, that's totally fine. We don't have to stick to family members. Essentially, it says the residence rules are now 2.5 years in the UK over the 5 years, and the rolling method does not apply anymore. This is correct. So, and then they say that they applied for settled status. In the last page before submitting, it shows the same rule. So they wonder if they've misunderstood the update. So I don't have an application to hand, so I don't know exactly what's said in the application, but I can tell you that the Home Office does apply the 2.5-year rule, not the 6 months in any 12 months over the rolling approach, as you rightly call it. So even if the Home Office information in the application form is not up to date, then the new approach where they look at just have you been here for 30 months over the last 5 years, that is the approach that is now taken. So you can meet either of the residency rules. It doesn't matter which one you meet. So the answer is, I hope that if you've got the 30 months in the 60 months, then your application should be successful, because that's what the approach they take now when they look at the applications, and they take that approach since the 16th of July. So that's been applied for a couple of months now. Okay. Person is an EU citizen, and they came to the UK 2 years ago on an EUSS family permit as the dependent of their father. They were 24 years old when they came. They have a girlfriend who lives outside the UK, and if they marry, can this person bring them to the UK? Yeah, it's a good question, and it shows a couple of things. So first of all, because you are a sponsored family member, you are not able to sponsor your own family members under the settlement scheme. It's only EU citizens who are resident by the end of December 2020 who are eligible to sponsor under the settlement scheme. So if you're a sponsored family member, you cannot sponsor your own family members under the scheme. That's one of the rules, and that's reflected in the withdrawal agreement. So when you are a sponsored family member, if you then have other family members who need some kind of visa sponsorship, you would have to look at the domestic rules, which I referred to in the last slide. And the thing is, when you look at the family visa rules, they do not allow someone with pre-settled status to sponsor. If pre-settled status holder is a sponsored family member, they cannot sponsor family visas, unfortunately. So you can only sponsor family visas once you get to settled status. So in your scenario, although you're married, and so being married, if you got married, so if you got married to your Bulgarian partner, it may be that your unmarried partner could meet the conditions of a family visa once you get settled status. But if you're married, then you definitely meet the relationship requirement. But if you marry them, as soon as you qualify, as soon as you get granted settled status, you would be able to sponsor them for a family visa. But you're not able to sponsor them whilst you are on pre-settled status. That's one of the rules. And so at the moment, your partner is not able to join you in the UK on a long-term basis because you're not eligible to sponsor a domestic family visa, I'm afraid to say. That's the way the rules operate at the moment. So it's quite restrictive. So if you're a sponsored family member, you can sponsor family visas once you get settled status, is the important point. So someone here is asking about a settled status application that they have made, having been granted pre-settled status, and about how long it should take. The answer is not always, there's no set amount of time. It sort of depends on what kind of checks the Home Office needs to make and if they need to ask you for more information. So it can be very quick. It can be a matter of days. Equally, it could be a couple of months. So it depends sometimes on the amount of applications the Home Office is processing at any one time. So don't worry if it's been a couple of months. That's fairly standard. So yeah, but there's no like set amount of time. I'm afraid you just wait. But you have your pre-settled status while you're waiting, so there's no issue there. So we have a question of how much money do you have to earn to sponsor? Sorry, I'm just trying to read the additional information. So they're saying that the family has British passports, but this person doesn't. Can they come to the country for longer than 90 days? They don't want settled status. They don't intend to live here, but they want to look after old family members. Okay, so the visiting rules, if we do it like so, essentially, if you're not coming to live in the UK, then you're probably your entry is as a visitor. Now, the visiting rules for the UK are slightly different from the rules. If you're a British national visiting the EU, you're allowed to go for 90 days into the Schengen zone in every 180 days. But the UK rules are a bit different. You're allowed up to 6 months as a visitor, as long as you meet the other conditions. So if you have British family in the UK and you wanted to come and spend some time with them to help them if they're sort of older family members, you could come up for up to 6 months to visit them, and so that is possible. You then have to leave again, and there's no set time you have to stay away. But if you came back quite quickly and tried to spend another 6 months in the UK, then you might be accused of looking to live in the UK on a permanent basis, and that's not something that is possible to do. So if you're looking to basically spend time with your family, helping them when you're coming as a visitor, that is fine. Obviously, you have to be self-funded. You need to be able to fund the trip, and have, if you were asked to show the immigration officials that you had enough money to support yourself while you're here. But if you can meet that, then it's possible to spend quite a bit of time here, 6 months, supporting your family. But if you're going to if you're going to frequently come into the UK, to do that, then you might want to speak to a qualified lawyer just to understand, like, what's the things that might catch me out. How much time is sort of spending too much time? There's no definitive answer to that question, but you can get some guidance on what might be possible without sort of, because you're not coming here to live, you're coming here as a visitor. Okay. Yeah, so someone's applied in August for a decision, so a couple of months doesn't, not surprising. We're not even a month yet, so hopefully, don't worry, it will get decided. Yeah, we've got another question on the application in the August. So I have a question about the deadline. So when we talked about the deadlines for people who have already been in the UK as tourists at some point since January 2021, does that apply to children under 21? Yes, it does. So if you have a child who visited the UK, my example was in January 2022, and then they're now looking to be sponsored to come here, their parent is sponsoring them to come and live here, then they would be held to the same late application rules as an adult would be. But because they're a child, in theory, they would have a more straightforward time showing, and also because they were only visiting. So if the child has come here for a visit and then wants to apply and has got to justify missing the deadline or applying after the deadline, they should be able to, I would hope. Okay, just getting through them. So someone here is asking about what's called the Surinder Singh route, which is a particular category of the settlement scheme, and they're asking about. They've been told that the withdrawal agreement doesn't apply to their case, and that is correct, because Surinder Singh cases are not covered by the withdrawal agreement because your sponsor is British, and that means that the EU Free Movement Directive does not apply equally. So the question is what rules apply, and it seems to be about travel, because you haven't had a decision, you've got a certificate of application. So the rules on traveling, even though you're not a withdrawal agreement category, the Home Office rules on traveling on a certificate of application are reasonably similar, but because what happens is, when you travel on certificate of application, you are asked to show that you may be asked to show you're eligible for status under the scheme when you try to re-enter the UK. And if you're under the Surinder Singh category, that is more complicated to show than it if you are the family member of a European national being sponsored, for example. So I would say that traveling as a Surinder Singh, awaiting the decision on a Surinder Singh case with a certificate of application, it would be very risky, and that you would risk not being permitted to re-enter. You might want to, like I say, speak to a lawyer to explain your situation, because I can't give you that advice, but I can see where the problem would arise. The Home Office Border Force might have a serious difficulty understanding your situation and whether they would permit re-entry. So, and then at that point, you potentially face a refusal of re-entry. So, traveling is really problematic with certificates of application. Unfortunately, even under the withdrawal agreement categories, it's a problem. But under Surinder Singh, it could be even more complex. I'm sorry to say. Sorry, I'm just trying to. Someone has asked about proving financial dependence for parents-in-law before Brexit, and they've sponsored their husband. Sorry, I think the question is whether they need to show that you were financially, or were your parents-in-law dependent on you before Brexit. The answer is, if they're being sponsored and they don't live here at the moment, then you don't worry about what happened before Brexit. You show dependency at the date they apply, so you don't have to go back to before 2020 if you're sponsoring parents to come now. If your parents are living with you, or your parents-in-law were living with you before the end of 2020, and now they're only coming to apply, for some reason they're very late, but if they're applying now, then you would go back to what was the situation at the end of 2020. But if you're talking about parents who don't live here now coming to join your parents-in-law, then they assess the dependencies, financial, if that's the case, they assess it at the date of the application. So we have a question. They have a child with pre-settled status, and this person has pre-settled status at the end of 2025. They will apply for settled status. Once they have got settled status, can they apply for the child to have settled status who has been here for 4 years? Yes, because, well, if you are the EU parent of the child and you are getting settled status, then once you have that, you can apply for your children to get settled status, even if they haven't lived here for 5 years, because children, or to under 21 children, or get settled status based on one of their parents being able to sponsor them, who also has settled status. So the question about children being children at birth, born in the UK, what happens if the parents had pre-settled status at the date of birth, but they were eligible for settled status, but the settled status was granted after their birth? So this goes back to what I was talking about. You would have to show that the parent was acquired withdrawal agreement permanent residence. The fact that they may have been eligible for settled status is not good enough itself. But if the parent with pre-settled status had lived here for 5 years at the date the child was born, there's a good chance the parent had acquired permanent residence under the withdrawal agreement, and therefore the child may be British. But yeah, if you have children born when you have pre-settled status, and you lived here for 5 years when your child was born, then you need to investigate whether you qualified for withdrawal agreement permanent residence, because that might mean your child is born British. So you should investigate that situation, I would imagine. But that's how it would look to me. Okay, couple more questions before the end. My brother is married to an EU citizen and holds settled status. His wife is now British. Can he apply from his daughter from a previous relationship to bring her to the UK? We're talking about a sponsored spouse who has a child who is the non-biological child of an EU national, but this EU national has also become British. So if that child is born before the end of 2020, then potentially they can be sponsored under the settlement scheme, because the the EU sponsor in this has also become British, it adds a slight complexity to the situation. It has to be looked at through a particular set of rules about what's happened to the EU national who's become British. Have they retained their EU nationality, for example? But it sounds like it's possible as long as that child was born before the end of 2020. It sounds possible to me, yes. Okay. So question is, could a dependent member spend half the year outside the UK and after 5 years be able to qualify for settled status? They have pre-settled status at the moment. Yeah, so I mean, when you have if your family member has pre-settled status, if they are in that dependent category, once they get pre-settled status, they don't have to stay dependent, if you like the dependency is only relevant to be issued pre-settled status. After that, the dependency is not as important. It's not important. So if you had a dependent parent who gets pre-settled status, after that they could spend 6 months here, 6 months overseas, 6 months here, 6 months overseas, and they would acquire the 30 months needed for settled status. And the fact, but you wouldn't have the Home Office saying, well, you weren't dependent in the periods you weren't living in the UK. So yeah, it would be fine. You just need to spend enough time as the sponsored family member to qualify for settled status. So that's how that would work. So again, I think this is a slight repeat of a question we've had, which is the dependency for parents-in-law strictly related to before the Brexit financial, or does financial support after Brexit count? So as I said, if your parents are not living in the UK and you're looking, or your parents-in-law, and you're looking to sponsor them now as dependents, then the situation is assessed at the date they need to respond. So the pre-Brexit situation is not relevant. It may be relevant if they were dependent back then, but if they weren't, and their dependency has arisen in, let's say, in the last couple of years or the last 6 months or whatever it is, if they're dependent when they apply, that's what counts if they are not already living in the UK. And maybe even if they are with you in the UK, it's only when the parents are living here before the end of 2020 that the situation pre-Brexit matters. If they weren't living here by the end of 2020, then you only look at the date when they come to apply for as a dependent parent or parent-in-law. So hopefully that's all clear. We have put out, sorry, the last thing I want to say before we finish is we have put a page on the website that we have, the EU Citizens UK website, that we try to publish information about the settlement scheme. We now have a page about sponsored family members, which tries to cover a lot of these issues because we recognize that they're complicated. So go and have a look. We will promote that page because it's been updated and given new information to do with deadlines and so on. So hopefully that helps people. But thank you very much for all those questions. They were all very interesting and important questions. Hopefully you got some answers that have helped. And as I say, we're happy to receive answers by email or by social media, and we'll do our best to get you information that helps. And obviously, if you're still not sure, then we do say go and speak to a regulated advisor, because sometimes that's the only way to really get clear information. But thank you very much for this evening. Thanks for joining, and we look forward to seeing you at the end of next month. Bye-bye.